Number 25, People v. Solomon.
Good afternoon, Your Honors. Daniel Blackaby, Sullivan County Assistant District Attorney for the people of the state of New York. A birth date is just a date. It is not a jurisdictional defect. This appeal has been moot since 3 months and 2 weeks after it was perfected. There are two categories of issues with indictments, and SCIs fall into either jurisdictional and non-jurisdictional categories.
Counsel, this case baffles me a little bit. So do you think that the indictment, the case was indicted, and then there's a Superior Court information filed while that indictment is live? Is that an error?
I think it depends on the supporting deposition that was attached to the initial misdemeanor complaint for endangering the welfare of a child. If that deposition included statements regarding oral sexual conduct, then it would have been proper because it was properly joinable with the existing indictment.
Didn't you concede error below in county court? You said the waiver procedure may not have been procedurally proper and admitted that there was an infirmity with the SCI?
I was not specifically that
I understand.
ADA. I think when you're trying to make an argument on the spot in court versus having the ability to go and look and find the document, we had to dig in the basement for the box that had the underlying misdemeanor complaint.
So you're saying now that that was an error, joining the SCI with the indictment?
I'm saying that it could have not been an error. Unfortunately, the documents were not included in the...
Could have not been? Either it is or it isn't. Was it permissible? Normally, you follow the criminal procedure law. If the case starts in the local criminal court, if they're felonies, you have a felony hearing, it's held. If there's no desire to have one, you dismiss, you go straight to the grand jury. But after a case is indicted, you plead to the indictment. Before, you could go to the special term judge and use an SCI. This case is kind of strange. What happened?
You know, I'm not really sure why they didn't simply take a plea to the lesser included offense. That would have been, basically everything that was said on the record would have been the same record, it would have been the same plea, it would have been the same facts.
Let's say we conclude it was an error on this record. What do we do with the indictment?
I think the indictment is valid as amended.
The appellate division said it wasn't validly amended, but they don't seem to have ordered any remedial action after that finding.
Right.
So what would we do?
So I think if, specifically what would we do if the SCI was
Right.
improper? Okay.
And now we're looking at the indictment, right?
So
What
if
do we
the
do with
SCI is invalid and should be done away with, then it's, you know, we're left with what happened to the underlying felony indictment. And here, the question is actually the same as to the indictment versus the SCI as it was.
Can we even reach that? Because the appellate division doesn't seem to have done anything with it, other than, it almost is dicta, right? They decided it, but they didn't order the indictment dismissed.
Right, and it is slightly confusing. I think myself and opposing counsel probably have different views on what still exists as a valid indictment in the lower court. And it's our position that it was when the third department reversed the SCI and sent it back, the case reverts to what was present immediately before the SCI was initiated. So you would have the indictment as amended, because that's how it's separated out before it's all put together and the SCI is signed. And so the question becomes whether the issue with the underlying indictment was properly raised by appellant respondent, in his response brief in the Court of Appeals, or if it should have been raised below, or raised as an ineffective assistance of counsel claim. But the actual analysis about that document is the same as it is for the SCI, about whether the issue is a jurisdictional or a non-jurisdictional question. And it's the people's position that the birth date here is one of the less fundamental flaws. It's not a jurisdictional issue. We were properly permitted to amend because the victim in this case is not identified in one manner. She's identified in 3 separate ways. Specifically in the indictment, she's identified as the person known to the grand jury. She's identified as less than 17, and we give the wrong birth date, which is a typographical error, which in this case is slightly more relevant than any other typographical error might have been in a different case.
So you're making an argument now as to the amendment of the indictment, or are you somehow trying to connect that indictment to the SCI combination indictment error?
So because it's the same error, and because under the CPL, both indictments and SCIs are treated the same, the amendment is, in our view, correct whether we're talking about the SCI or the underlying
So are you
indictment.
saying it's supposed to be treated as one instrument under the CPL because of
No,
the
no, no,
consolidation? Or are you saying we still look at it as 2 separate,
So it's 2 separate questions.
well, 2 separate instruments, 2 separate?
Yeah, they are 2 separate documents. It's
Even
just
though they were
that,
consolidated for
Right.
purposes of the plea?
but if the SCI is been properly reversed, then we take, the SCI is out. It's been dismissed. And so what's left is the
But
indictment
your
as
position
amended.
is it should not have been, correct? Isn't your position that the SCI is not jurisdictionally
Yes,
defective?
yes, both that the indictment is jurisdictionally okay and that the SCI was jurisdictionally okay, because there are the 3 different ways that she is identified, specifically by name. We
But
know who
if
this
the
person was.
SCI is not valid, is it your argument that the indictment could still survive because that's a typographical error? Is that what you're arguing?
Yes, that regardless of the outcome for the SCI, it's the people's position that there is a valid indictment charging 5 felonies.
And the appellate division disagreed with you,
Yes,
but they didn't do anything with that.
correct.
So I don't understand how you're able to appeal that to us because you're not aggrieved by the appellate division order.
So we're aggrieved by the remand of the SCI. The people were asked by respondent to offer a plea. We reconsidered our position. We were ready for trial. This was the Friday before trial was to begin on Monday. We offered him a plea. He waived appeal. These documents were considered until 7 o'clock at night, the day on that Friday. We had him, the defendant, execute a statement admitting to the felonies so that we would hold this open because we were so unsure that he would actually take this plea. And it's our position that everything he's done since is in derogation of that plea. He's effectively attempting to walk out on his plea. And that's where the people are injured, is that we expected finality.
I
This
understand
document
your
would-
view of that process, but my problem is more localized with the appellate division. So you have a ruling in the appellate division that says this indictment was improperly amended. They don't dismiss the indictment, so I'm not sure what you're appealing to this court.
Oh, so we're simply appealing their decision on the SCI. That's where our primary injury is. We have remedies below if it's necessary,
Let's say
but
we
we think they were
disagree
incorrect.
with you on that. What happens?
If you disagree with me that we were injured
No, if
by-
I disagree, if the court were to disagree that this SCI is proper, for whatever reason, so the SCI, as you say, is out,
Okay.
what happens to the indictment?
I think the indictment is still valid, because the remedy for a reversal in the third department is that it goes back to the status before the document was
So
entered.
what's the aggrievement again? Because if the indictment survives the reversal of the SCI, and you said, I think just a moment ago, you still have options available to you.
We do have options. So we expected this to be over when we gave the defendant the SCI. And what the appellate division did was to say, no, the SCI is not valid. Now you go back and have an indictment, and you start all over again.
But they said the indictment was improperly amended. Let's assume we agree the SCI is improper. It has to be tossed out. So where are you when you go back with respect to an indictment that the appellate division has found was improperly amended, but we can't reach?
Okay, I think I get where we're trying to. So if the third department's functionally dicta, because there was no remedy there was no decision as to go back, is accurate, then the defendant was never in jeopardy, and the people have the ability to represent to the grand jury. And he would be again, or then for the first time, charged with 5 felonies and a misdemeanor.
Thank you, counsel.
Good afternoon, Your Honors. May it please the court, Nathaniel Marmer for defendant and respondent. I'd like to take Judge Garcia's questions because I think they really go to the heart of what I think the court needs to do here and how to sort of think about this case. And I'll just briefly, there are sort of two, I'll sort of call them merit issues, right? One is the post-indictment SCI, which is improper for a host of reasons. It's done off a misdemeanor. They're not being held for grand jury action on that misdemeanor. It's not extant when he supposedly waives. But let's put that aside. They've somewhat conceded that. Then we have the other issue, which was the focus of the third department, which was whether they call it typographical error. We think it's much more, just so the court's aware what happened. It's not just a typographical error. They actually switched the dates of the 2 girls who were females, I should say, sorry, who were in the grand jury, one of whom he had a relationship with. And they repeated that several times. They did it in the indictment. They did it in the bill of particulars.
And I understand your view
Okay.
on the improper amendment, which, as I read it, the appellate division agreed with you on, but ordered no remedy.
So let me, yeah, I'm sorry.
So what do we do with that?
Okay.
Assume we agree on the SCI.
Okay, so this is how I would like to see it go and what I think the court can do. The validity of the amendment is not before the court. Okay, there was no adverse ruling, what we call it dicta, whatever. That was not the declaration. That was not the decretal paragraph of the third department. The third department said we vacate the plea and remand. The people in their brief do not ask for any remedy with respect to the amendment. Their brief, and just reading their point heading, they deal with the fact of whether the SCI was jurisdictionally defective or not. The path of least resistance, and what I think is really the only one that's consistent with what is the court's jurisdictional obligation here, is to decide what I think is the easy and somewhat conceded issue, which is the fact that this SCI could not have been filed at the time it did in the manner in which it was, putting aside whatever significant problems there was with this to-wit clause, and I think the court knows our arguments on that. And the rest, the court should not stray further than that, because I think there you're getting into some jurisdictionally...
Should we send it back to the appellate division?
Well, no, because if you're affirming, the only issue on appeal here, should the plea be vacated. That's what people sought leave on, what the court took leave on. The manner in which you do it, I think, is the easiest way to do it is
So are you saying what happens in the future is if the people do as it was suggested by your opponent and they could file charges again, that's left for another day?
Well, they're in the lower court. They have an indictment. They do have what we'll call a strong advisory opinion by the third department, if you want to put it that way. We're all trying to characterize it fairly. But that is what would happen here, to be candid. But I don't know that the court has another way of getting to it without.
So then that view would be then the people proceed at their peril if they try to move forward on the original indictment, or they can do something else.
I think peril's a strong word, a good word. The problems, and I know we're not going to get too far into the merits here because I think you have the issue, but it's so problematic what happened here with this indictment and the way they attempted to amend it, that the people, if they truly want to go forward with this case, which is obviously their prerogative, they should go back to the grand jury and present it correctly.
Is it clear that the rule from Boston applies to a plea to a misdemeanor? Because Boston applied to felonies, and the rationale behind it was your right in a felony to be, have an indictment in front of the grand jury. But for the misdemeanor, you wouldn't have that, so.
The SCI stems from the Article 1, Section 6 of the Constitution, which speaks to the right to be indicted by a grand jury, or to have a Superior Court information filed, and that it has to be extant at the time that you're there. And maybe I'm not answering the question. You're asking more specifically, can it be done on a misdemeanor?
Yeah, what I'm asking is that the rationale that's expressed in Boston really turns on the fact that for felonies, you have a right to have the charges presented to a grand jury, right? And that's what's being protected, I think, by the rule in Boston. But where the plea, let's say, here is just to a misdemeanor, it's not clear that Boston would foreclose a holding that said, because that constitutional right is not at play with regard to a misdemeanor, this process that you'd have to follow for a felony, you don't have to follow for a misdemeanor.
Well, the process is still set forth in the criminal procedure law. There may be a policy that Your Honor is getting to, but quite frankly, you could just plead to a misdemeanor complaint. You don't need to do a Superior Court information to plead to that. And if you look at this court's cases in D'Amico, Trulock, every single one, they all say the exact same thing, which is a Superior Court information happens when you waive to, when you are being held on a felony complaint. Anybody who just does this knows that if you're going to try to get around that, you got to go back, you got to arrest them on a new felony complaint and bring them in. And
There was a misdemeanor complaint originally, though.
It was a misdemeanor complaint originally. He was not held for grand jury action on that because it was a misdemeanor complaint. We don't know whether it was presented to the grand jury. It certainly wasn't voted out by the grand jury. He was certainly not being held on it at the time that he waived. And quite frankly, if we look at the page 828 of the record, that's not actually what he was waiving indictment on. He was waiving indictment on a count that was already in the indictment. He was not waiving as to the misdemeanor complaint. And that's at 828. So, again, I think for that part of it is very simple, and I think given the complexities of this case, I think the simplest way, quite frankly, is for the court to just say, this is, can't do this. I would invite a memorandum.
They can't do what? Can't do
You
what?
can't, sorry, the this in that sentence was have an SCI after indictment, and whatever holes that they're trying to poke in this, they just don't, it just doesn't
Okay.
fit.
So let me ask you about the date of birth then. Why isn't that, given that there's already a statement that the victim is not 17 years old, than 17, why isn't that superfluous and doesn't render it defective?
Because under the criminal procedure law, and as this court says repeatedly in INO and in all those cases, an indictment is jurisdictionally defective if the facts that it does state do not make out a crime. And that's
There are
what
some
occurred.
facts that do. Is your rule that if there are facts that do, facts that don't, that clash renders it defective?
Well, what this court said in Randall was when there is that inconsistency, it's the factual, because those are the more specific
Yes.
parts of it, that will control. And that's what the lower courts have done, and they've had these, we call these the negate cases.
But what does that mean when you have two facts
Well, if you
that are
say,
in go ahead.
well, take for example, if you had a count that said he possessed a firearm, to wit, on a certain day he had and opened and showed a switchblade,
Yes.
we would think that the defendant was not guilty of that crime because the facts negate the charge. And that's what's coming out of the grand jury. So the grand jury is indicting him for something that was not a crime, notwithstanding that they recited the statute or the elements. The specific facts that they're saying are not a crime.
Well, you're saying that the statement that the victim is under 17 years old is not a factual statement?
The statement that she, well, the statement that she was born on a given day.
No, that's a factual statement. I
Oh,
don't
okay.
disagree with that. The other there's two statements,
Right.
right? That's the problem, we've got two statements.
see.
If you only had the date of birth statement, this would be a very easy
I
case.
understand.
Right?
I think the better way for me to phrase it then is how the court uses the terms, which is the accusatory part, and that's what I should have said earlier. The accusatory portion of the indictment is considered to be the statutory citation and the recitation of the elements, and then the factual portion, and I should have said that before, that's what really trumps, and that's what Randall says.
If the birth certificate were presented to the grand jury and was part of the record, does that make a difference?
Well, I think the judge here did look behind the grand jury minutes and found that, so I'm not going to say that that wasn't there, but that doesn't matter. It's what the grand jury voted out, and they, I mean, and again, this wasn't, I'm not sure this would have made a huge difference, but it wasn't as if a 1 was changed to a 2. They actually switched the birth dates of 2 separate females in the grand jury.
So if they didn't include the date of birth, it would have been sufficient?
Sure.
Not a problem.
I mean, that's a straightforward indictment, right? That's not a problem.
Thank you,
I see that my time is up. Thank you.